Hello students, how are you? I hope you all are fine. Let's today discuss the evidentiary value of FIR, that is First Information Report in the criminal trial in India. What is its actual value? Why is it so much important in criminal trial? And what are the benefits of lodging prompt FIR? You see, FIR, that is First Information Report, is lodged by the victim of the crime or any of the witnesses who has seen the crime being happened in the police station. So that police station may be having the jurisdiction over the area, or it may not be having the jurisdiction over the area. That police station has to write down whatever he is saying to the police officer, and the police officer is duty bound to register the FIR, that is First Information Report. And if it comes out to be a cognizable offense, this is very important. Only in case the police officer comes to the conclusion after a preliminary inquiry that the case involves a cognizable offense, then it is his duty, it is his mandatory duty to register the FIR. He cannot say that I will not write the FIR. He cannot say that I have no authority to write the FIR or to register the FIR, because in case after preliminary inquiry it comes out to the police officer comes out to the conclusion that it is really a cognizable offense which has happened, it is his pertinent duty to write down the FIR there and then, immediately. So this is given under section 154 clause 1 of CRPC. Now it is known as 173, section 173 of Bharatiya Nagrik Suraksha Sanhita. So what is the main purpose of FIR? It is to set the criminal law in motion. It is the first step before the investigation actually begins. So as I've already told you, it is for the cognizable offense only. What is cognizable offense? It is only they are those offenses which are basically serious offenses like rape, murder, dacoity, and these offenses are basically offenses against the whole society. Whole society is concerned about these things, and these culprits who commit these type of offenses, they should be nabbed immediately, they should be arrested immediately, and they should be brought before the court of law. So these are the cognizable offenses. Most of the cognizable offenses are those offenses who are having more than 3 years imprisonment in CRPC, but there is no hard and fast rule, but usually these offenses are having more than 3 years imprisonment maximum, and maximum can be life also, or it can be death also, but minimum is 3 years or more than 3 years. But there is no hard and fast rule. For this you have to see the table of the CRPC, because there are many offenses which are having punishment less than 3 years, but even then they are cognizable. So you have to see the table of the CRPC. Now Bharatiya Nagrik Suraksha Sanhita. You see, each and every minutest details need not to be given by the informant in the FIR, but the FIR must contain all the essential facts which are very helpful in making out the crime. So it is also not mandatory to give the names of all the witnesses if the victim is registering an FIR in a police station and the victim is not able to remember all the witnesses. So it is not fatal to the case. But not mentioning the material witness's name, who is totally material in this case, very important witness, that is a fatal thing, and it may affect the trial in the court, and the prosecution may be at the backstage, or it may be at the back foot in the trial, because the material witness's name is not being written by the police officer and it has not been given by the victim or the informant. So it can affect the trial, and the prosecution case becomes a little bit weak in the trial process, because the opposite advocate, that is the accused advocate, will point out this thing during the arguments. So otherwise prompt lodging of FIR is very important. This is also one of the main important issues, that immediately the victim of the offense or the informant should go to the police station and he or she should promptly lodge the FIR so that the investigation can begin as soon as possible. But sometimes witnesses approach the police afterwards also, after registering the FIR. So those witnesses can come afterwards also, because they are not knowing about the case, that the case has begun or somebody has registered the FIR. So they somehow come to know about the case, then they go to the police station, then they record their statements under section 161 CRPC. Now it is some other section of Bharatiya Nagrik Suraksha Sanhita. Now whatever is written by the police officer in the FIR, it has to be proved in trial by the prosecution. You know this, and prompt lodging of FIR is very important, and court will basically scrutinize the FIR. It is the basic document. It is the basis of the investigation. It is a very important document. So very valuable piece of evidence, very vital piece of evidence during trial, FIR, you see. But if you say that FIR itself is a very important piece, or it's a substantive evidence, that is also wrong. It is not a substantive evidence that alone on the basis of FIR the court will punish the accused. No, the police or the prosecution has to stand on its own feet. They have to collect the independent evidence also. They have to corroborate with the FIR. FIR itself is a first information report. You cannot say that everything written in the FIR will be true. Most of the things can be true, but some things may be false also. The person lodging the FIR, you cannot go into the mind of that person. The court is not going into the mind of that person. But whatever he is saying is totally wrong, true. For that, he has to be facing cross-examination by the accused advocate. It is the duty of the accused advocate to point out the wrong or the falsity in the FIR. They have to point out all those things which are not consistent during the statement in the court and whatever they have written in or whatever they have stated in the FIR. There is inconsistency in the FIR and the statement given in the court by the same informant during the examination in chief, and then during the cross examination the accused advocate will cross him. Now, these are the inconsistencies, because FIR itself is not a substantive evidence. FIR is a very valuable piece of evidence. FIR is a very, very vital piece of evidence. It is the switch, or it is the main switch through which the fan revolves. It is the point at which the investigation begins, because until and unless FIR is not registered, investigation will not begin. But saying that FIR itself is enough to put the accused before bars, no, that is wrong. The prosecution or the police has to bring before the court all the independent evidences through which the court will come to the conclusion that yes, that the accused has committed the offense. And that independent evidence may be the expert evidence, the medical evidence, doctor evidence, medical legal report of the doctor, or fingerprint expert. There are many experts. There can be, if there is a murder, for example, from a gunshot, then there can be an FSL report also. You see, then there is a post-mortem report also. Then there is many other evidence or other things which are collected by the police at the crime spot. Then they send that mud or the blood stains or whatever thing they have collected. They will send that to the lab. And what is the lab report about this? What is the doctor's report about the crime being committed? For example, if there is a physical injury, is it through a sharp weapon or through a blunt weapon? These all are the basic evidences given by the experts. So on these evidence, most of the case depends, and so these are the evidences which can make or break the criminal case. So just saying that FIR itself is a substantive piece of evidence, that's wrong. And Supreme Court also in many cases has ruled out that FIR is a very vital piece of evidence, but saying that it is the only piece of evidence based on which the court can convict the accused, that is wrong. So what is the evidentiary value of FIR? Basically, Evidence Act under section 157 of Evidence Act, section 157 says that FIR can be, now it is section 160 of Bharatiya Sakshya Adhinam. Earlier it was 157 of Evidence Act, now it is 160 of Bharatiya Sakshya Adhinam, which says that FIR can be used to corroborate the informant. If the informant who has lodged the FIR, and in the trial there is examination chief of the informant by his own prosecution advocate, so whatever he has stated in the FIR, so that the same thing he has to say in the court also. during his examination in chief. So the prosecution advocate, while examining him in chief, he can put him suggestions, or he can corroborate him whatever he has said in the FIR earlier. But that is the former statement given by him in the police station. So that former statement, whatever he has said in the FIR, now whatever he is saying in the court, that can be corroborated by the FIR. That is the former statement. So this is the value of the FIR. It can be used to corroborate the statement of the informant during the examination chief under section 160 of Bharatiya Sakshya Adhinam. There is one more important value or use of FIR, that is to cross-examine or contradict or refute the evidence of the informant. So during the examination chief, corroboration is there by the prosecution advocate, but during the cross-examination also there is a very important use of FIR by the opposite advocate, that is the accused advocate, that is the defense advocate. The defense advocate during cross-examination of this informant who has lodged the FIR, during his cross-examination, the opposite advocate, that is the defense advocate, will put him some sharp questions. He can cross-examine him, and during cross-examination he can put him certain questions, that you have said these and these things in the FIR, but now you are saying this, or you are saying these things, but earlier you have said this thing in the FIR. It is totally contradictory. So in order to contradict him, that portion of the FIR has to be shown to him by the advocate. The advocate who is cross-examining the informant, if the advocate proposes to contradict the informant on whatever he has said in the earlier statement, that is in FIR, now he is saying something else, for contradicting him, the advocate or the defense advocate who is cross-examining the informant, he have to show that part of that FIR to him. But if it is the purpose only for cross-examining him, then that part may not be shown to him. It is not necessary to show him that part, but in case to contradict him or to refute him, then that portion of the former statement, that is FIR, is to be shown by the advocate to the informant during his cross-examination, and this is given under section 148 of Bharatiya Sakshya Adhinam. Earlier it was 145 of Evidence Act, now it is 148 of Bharatiya Sakshya Adhinam. So this is important, very important thing. Then FIR is the basis of investigation. If there is no FIR, no investigation begins. This you should put in your mind. So it is though it is not the conclusive evidence of the facts mentioned in it, but it is very valuable piece of evidence, because from that it sets the criminal law in motion. So I've already told you, it is used for corroboration, it is used for contradiction, and one more important value or use of FIR, and it can be used as evidence or substantive evidence also, and that is dying declaration. Yeah, if the person who lodges the FIR, that is the informant, he says something in the FIR that he is about to die because, or he is in danger because some person is about to kill him, and he is scared of these things because he is under the apprehension that he may be killed, and whatever he is saying, it has been registered by the police officer as a FIR. So, and afterwards actually he has been killed. The fact says that after lodging the FIR, in which he has apprehended that I may be killed by some person, and after lodging the FIR he is actually killed. Now that piece of evidence is very crucial. Whatever he has said in the FIR, that becomes a dying declaration, that becomes the last statement of the accused, and it may be presumed to be the court to be truly said by him, because last statement before death, it is presumed by the law that it is true until and unless it is refuted by the other party. So that becomes a substantive evidence under section 32 clause 1 of the Evidence Act, now section 26 of Bharatiya Sakshya Adhinam. You see, so FIR can be used for cross-examination under section 148. It can be used for contradiction, to contradict the informant under section 148, but for that the accused advocate has to show that part of the FIR to the informant, because it is the purpose to contradict him. For cross-examination, there is no need to show the FIR. Then FIR can be used for corroboration also by the prosecution advocate while examination in chief, and that is given in section 157 of Evidence Act, now 160 of Bharatiya Sakshya Adhiniyam. Then besides all these important things, under section there is one more important thing, and that is that if the accused himself lodges the FIR, because though it's a very rare thing, because a person kills somebody or there is a rape accused, or if the accused commits some murder, any offense you may imagine. So if after committing any of the offenses given in IPC, now Bharatiya Nyaya Sanhita, if the accused goes to the police officer, to the police station, and he lodges the FIR against himself, he himself confesses before the police officer that I am the person who has killed that person, and now I am giving the statement. Now, what is the value of that FIR against him? It can be used in the court by the prosecution against that person who has himself lodged the FIR against himself? So this is the main important question which can come in your judiciary exams. So the answer is that it cannot be used for either for corroboration or for contradiction, because the accused cannot be a prosecution witness himself. He cannot be a prosecution witness because he himself has lodged the FIR against himself, and he has confessed his crime. And it cannot be used for the defense witness also under section 315 of CRPC, and now it is 353 of Bharatiya Nagrik Suraksha Sanhita. It cannot be used for a defense witness also. So, and basically under section 25 of the Evidence Act, and now it is section 23 of Bharatiya Sakshya Adhiniyam, it is said that no confession given to the police officer can be proved in the court of law. Yes, no confession given by the accused person before the police officer can be proved in the court of law. It is given under section 25 of the Evidence Act, now section 23 of the Bharatiya Sakshya Adhiniyam. So this section also hits this thing. If the person confesses his guilt before the police officer, and he lodges FIR against himself, then that piece of confessional statement cannot be proved. That piece of evidence, that piece of FIR cannot be proved against that informant that is accused in the court, because the statement or the confession given before the police officer cannot be proved under section 23 of Bharatiya Sakshya Adhiniyam. But otherwise it is relevant. You see, the informant himself has lodged the FIR, and he says to the police officer that I have committed the crime. So for any other purpose, FIR cannot be used against him in the court by the prosecution. This I have told you earlier. But it can be used as a proof of his conduct, subsequent conduct under section 6 of Bharatiya Sakshya Adhiniyam. Yes, it can be used as a piece of evidence to prove his or to show his subsequent conduct under section 6 of Bharatiya Sakshya Adhiniyam. Earlier it was section 8 of Evidence Act. And if the FIR given by the accused himself is non-confessional, then it can be used as an admission against him under section 21 of Evidence Act. Now it is section 19 of Bharatiya Sakshya Adhiniyam. It can be used as an admission against the informant. It cannot be used as a confession, because it is hit by section 23 of Bharatiya Sakshya Adhiniyam. Earlier it was 25 of Evidence Act, but it can be used as an admission against him under section 19 of the Bharatiya Sakshya Adhiniyam, and that also if it is non-confessional. And as I've already told you, it can be used as a proof of subsequent conduct, because after committing crime, he goes to the police officer, he registers the FIR against himself. So that is his subsequent conduct after committing the crime. That subsequent conduct is very important. It can be taken into account by the court during his conviction, and that is given under section 6 of Bharatiya Sakshya Adhiniyam. So these are the only limited uses of FIR in the trial. Otherwise, it's not a substantive piece of evidence. So there is one more important value or use of FIR, that FIR can be used to impeach the credit of the maker of the FIR. Who is the maker of the FIR? Informant. The FIR, that piece of evidence or the FIR itself can be used to impeach the credit of the informant who has lodged the FIR. And it is used, who uses this thing to impeach his credit? The opposite advocate, the advocate of the accused. So the defense advocate or the accused advocate uses this piece of evidence, FIR, against the maker of the FIR to impeach his credit under section 155 clause 3 of Evidence Act, now 158 of Bharatiya Sakshi Adhiniyam, and this is done in the stage of cross examination. So this is very important, the evidentiary value of FIR. And what are the provisions of CRPC? Now Bharatiya Nagrik Suraksha Sanhita regarding FIR, it is 154 of CRPC, now 173 of Bharatiya Nagrik Suraksha Sanhita, 173, 174, 175, very important, and up till 193. Earlier under section 173, challan or police report was given by the police officer to the court. Now under section 193, challan or police report is to be given by the police officer in the court of law, that is the Ilaka magistrate or the judicial magistrate who is having the jurisdiction over that area. So all these sections have been changed. So in the Bharatiya Nagrik Suraksha Sanhita, earlier it was known as CRPC. So this is the thing. And what are the important cases? There is one important case, Siddharth Vashisht, that is Manu Sharma versus State of Delhi. So this is the 2010 Supreme Court case. Famously it was known as Jessica Lal's murder case. So in this case, model Jessica Lal was found headshot was given to her in her head by Manu Sharma. So actually it was a restaurant type of thing, and he asked for some more drinks, but she refused, and in a fit of rage he killed her by giving him a wound shot here. So he managed to escape from there, but somebody who was a witness, prime witness, actual witness in that area, in that restaurant, he called the police over the phone, and he named the Manu Sharma and his associates who were there. There were 3 persons. Then the Manu Sharma and his 3 colleagues were arrested, associates were arrested. And so the main question here, as far as FIR is concerned, is whether telephonic information given by the prime witness or actual witness who was there during that actual crime, that called telephonic conversation can be regarded as a FIR or not. Basically in this case, that telephonic conversation was not a cryptic message. There is a Supreme Court ruling that that telephonic conversation should not be a cryptic message, because if the person is giving a call to the police officer and he's the actual witness of the crime, so he should give his name, he should give the name of the accused also. If he knows the accused, he should tell whether the cognizable offence has been committed or not, what offence has been committed. He should give the details of the offences. He should not be telling false. Everything truly he has to state in the phone call. Then only that phone call can be regarded as a proper information, and the FIR has to be written by the police officer. This is very important. Not every cryptic message is regarded to be a FIR. Only those messages which are totally authentic, and the person who is calling the police officer through his phone is giving his own name also, he is giving the place of occurrence also, he is giving the witness's name also, he is giving the name of the accused also if he knows the accused, and is given every detail of the cognizable offence. Then that telephonic conversation can be regarded as an FIR. It can be basis of FIR, and the police station officer, after listening or during the process of listening, he's writing that FIR. So that FIR is totally proper. So in this case also, the main issue was whether the wireless or the telephonic conversation was it can be reliable. It can be the basis of the conviction of Manu Sharma. So Supreme Court in this case held that communication or the wireless communication can be basis of the conviction here if it is not vague or if it is not cryptic. And here it was not vague. He actually told the name of the Manu Sharma to the police officer, so it can be basis of the conviction. And actually who telephoned the police officer, he was witnessing, he witnessed that crime. He saw Manu Sharma giving a wound shot to Jessica Law. So he was the prime witness. So whatever said in the phone call, that was totally correct, and it was not vague or cryptic, so it can be the basis of FIR. In Tehel Singh also, Tehel Singh versus State of Punjab 1978, the same thing occurred, and this was the earlier case. Yeah, Manu Sharma case was of 2010. The judgment was given in 2010, and earlier in 1978, Tehel Singh versus State of Punjab also, the main issue was whether the telephonic conversation can be the basis of FIR. And this also it was held by the Supreme Court. Yes, telephonic conversation can be the basis of FIR, and if it should be reduced by the police officer in writing. It should not be cryptic, it should not be vague. It should, whoever is phoning the whoever is calling the police officer on the telephone, he should give his name, he should give his residence, place of residence. He should tell whether a cognizable offence has been committed or not. If he knows the name of the accused, he should give the name. And if he doesn't know the name of the accused, that's okay. But if he actually knows the accused, and even then he's not giving his name, then it can be fatal in the trial. It can be fatal to the prosecution case, because who is giving the phone call, he actually knows the name of the accused, he knows him, then also he's not giving his name in the phone call, then it can be then it can be totally fatal to the prosecution case. So these all things are very important to be considered, whether telephonic conversation can be considered as a basis of FIR or not. So it should not be vague, it should not be cryptic, it should be written by the police officer then and there, then only it can become the basis of FIR, then only it can be regarded as a proper FIR. This was also held by the Supreme Court in Tehel Singh versus State of Punjab in 1978. Then very important landmark case is Lalita Kumari versus Government of UP 2013. Very important case. This was the actual main landmark case regarding importance of FIR in the criminal trial is concerned. So in this case also a writ petition was filed in Supreme Court by the Lalita Kumari's father, Bhola Kant, under Article 32 of the Constitution of India. Lalita Kumari, that is her minor daughter, was kidnapped, or so somebody has taken her away, and father lodged an FIR in the nearest police station. After registering the FIR, the police officers didn't do anything. They didn't take any action. Then he filed writ in the Supreme Court under Article 32 of the Constitution of India, and then the 5-judge constitutional bench held that it is the duty of the police officers. This is the actual judgment given by the Supreme Court. I may be my words may not be the same, but what the crux of the judgment was that Supreme Court examined the mandatory requirements of Section 154 Clause 1 of CRPC, now Section 173 of Bharatiya Nagrik Suraksha Sanhita, and Supreme Court held that it is the duty of the police officer to register an FIR. He cannot say no to that, because if it comes out to be the case of a cognizable offence, if it comes out to be a cognizable offence, then it is the mandatory duty of the police officer to register the FIR. He cannot reject that thing. He cannot say no, I will not register. He cannot say that I will conduct a preliminary inquiry for that. No. If it comes out from the statement given by the informant that there is a cognizable offence which has been committed against the victim or any other person, then there should be no preliminary inquiry before writing the FIR, before registering the FIR. This is given in the Lalita Kumari case. This is very important. Most of the police officers, what they did, that they conducted a preliminary inquiry. Even after knowing that the cognizable offence has been committed, they didn't register the FIR, they conducted preliminary inquiry. The purpose of preliminary inquiry is only to see whether cognizable offence has been committed or not. The purpose of the preliminary inquiry is not to see whether the information given is right or not. No. Whether the information given is totally correct or not, that is not the main purpose of the preliminary inquiry. The main purpose of the preliminary inquiry by the police officer who is duty bound to register the FIR is to know whether a cognizable offence has been committed or not. And if it comes out to be that cognizable offence has been committed, then there is no need of preliminary inquiry. Immediately then and there, FIR has to be registered by the police officer, and all the procedure given in the Section 154 CRPC, 155 CRPC, 156 CRPC, and other section up till 173 of CRPC, up till the stage of presenting the challan, all these sections are mandatory to be followed by the police officer. This was given in Lalita Kumari's case. Because FIR is the stepping stone of the whole prosecution case. If it comes out from the statement of the informant that cognizable offence has been committed, there is no other option by the police officer. He has to register the FIR. He cannot conduct a preliminary inquiry. The only scope or only purpose for preliminary inquiry before registering the FIR is to know whether a cognizable offence has been committed or not. This was given under section in this Lalita Kumari versus Government of UP 2013 case, very important landmark case. So at the end, I am again saying that FIR itself is not a alone piece of evidence on which the prosecution will stand. FIR itself is not a substantive piece of evidence on which the court will put the accused before bars or he can be convicted. No, FIR, though it's a very valuable piece of evidence, it starts the investigation. It's the stepping stone of the investigation. But the police officers or the prosecution has to stand on their own feet. They have to show to the court all the substantive evidence, all other evidence, expert evidence, the post-mortem evidence, or any other independent evidence. They have to stand on their own feet. Just on the basis of FIR, they cannot prove the case against the accused. Accused have to be presumed innocent until proved guilty. So all the charges made against them by the prosecution, they have to prove them in the court of law. Until and unless they don't prove that case beyond reasonable doubt, the court will not convict him. So this is the main principle of the criminal trial. The burden of proving him guilty or burden of proving him wrong in the court is on the shoulders of the prosecution. Court will presume the accused to be innocent, totally innocent, until and unless it is proved to be he is proved to be guilty by the prosecution. The burden is on the shoulders of the prosecution. You see, so because accused advocate is ready for cross-examination by of the prosecution witnesses. Prosecution witnesses may be many. Prosecution witness 1, prosecution witness 2, because for example, if it's a rape case, the victim girl, she himself is the prosecution witness 1. So she has to face the cross-examination. Even the murder accused, he himself is a murder victim, though he is now dead. But other persons who have seen him while he was dying and they have seen all the incidents of the actual murder taking place, they are the main prosecution witnesses. Prosecution witnesses 1, 2, 3, all these. So they have to be proved wrong by the accused advocate through examination, cross-examination. They have given their statement to the police officers. You see, during the investigation, now the same statement they have to give before the court during the examination in chief. So then they are to be cross-examined by the accused advocate. So this is the process of the criminal trial. See, so lot of burden is there on the shoulders of the prosecution to prove that the accused has actually committed the crime. Until unless they didn't lose that burden, the accused will presume him to be totally innocent. So these were the very important points which I have made in this lecture. I hope you like this lecture. I will put more videos on very important issues, and especially for those who are preparing for judiciary exams. I again say you, those who are preparing for judiciary exams, especially in Malwa area of Bathinda or any other area of Punjab, they need not to go to Chandigarh or Delhi for this. They can come, they can visit me, and they can prepare for the judiciary exams as soon as possible. Thank you very much. Thank you.